Okay, prosecution has a response to the defense motion to sanctions, which I'm not going to read word by word, of course, because you know they do all the case law. Coming out of the people of Colorado by and through Linda Stanley, District Attorney for 11th Judicial District, by and through her duty-appointed Deputy District Attorney, and respectfully submits to the Honorable Court the people's response to a defense supplement motion. Yikes! Okay, that's a lot. Defendant has been charged with 1 count, each of first-degree murder, tampering with the deceased human body, tampering with physical evidence, possession of a weapon, and attempt to influence a public servant. Events that happened on or about May 9th. The people have produced tens of thousands of pages of discovery and hours of video and audio recordings. The people have conferred with the defense on multiple occasions and provided discovery in a timely manner. It should be noted that it appears the defense has stopped trying to confer with the people as their last request for discovery was made directly to the court before the last hearing. Despite this, the defense persists on filing discovery motions, asking the court for doctrine sanctions of dismissal for what amounts to disagreements among law enforcement timing. In the defense last motion, they are asking the court to dismiss first-degree murder case because a former CBI agent who has been really discredited an opinion on the timing of arresting the defendant in the case. The defense contends that if it had known about this, they would have cross-examined the agent when the case would have been found for over court. This is utter nonsense. Of course, these attorneys have also advocated preposterous notion to the court that the 11th Judicial DA, the FBI, CBI, Chief County Sheriff are some grand conspirators to suppress discovery that we have already timed provided. Oh boy. Okay, the facts. December 10th, people received what was referred to as a Brady letter from the Colorado Bureau of Investigation regarding one of the agents, Joe Cahill. The letter indicated the impact on Cahill's credibility was the result of accidental discharge, firearm, and unrelated to this case. The people immediately turned over the letter to the defense. On multiple occasions, the defense demanded the people provided the internal investigation on Cahill. Each time the people informed the defense that we were not in possession or control of the file, and they would need to file a subpoena to obtain the information. Finally, the defense did that. Pursuant to Colorado law, the court took IA file to determine if information was relevant to the case. February 3rd, 2022, the court released a copy of the IA to the people and defense. The defense has taken bits and pieces out of context in the IA to claim that there's discovery violation, arguing that because Cahill opinion on what the defendant should have been arrested is exculpatory and should not have been discovered. The defense uses a statement that Cahill said the arrest of the suspect now is the worst decision that had been made. Cahill also indicated in the IE that he thought the arrest of the suspect in the investigation was premature, and that the arrest was hasty. It also appears Cahill was put out because he could not be present at the arrest due to him attending the arrest. What? Okay. He could not present at the arrest due to him attending the arrest. Okay. Hey, people, I'm reading her words. Even though he spent a year of his life putting together the investigation, at no time did Cahill say that he did not think there was probable cause to arrest or that he thought the defendant was not guilty of murdering his wife. Okay, and then they go into case law. Okay, Colorado Supreme Court, United States have been explicit in the limitation of discovery in the case. In general, discovery in criminal cases is governed by, they go to case laws, There's no general constitutional right to discovery in a criminal case, and they go on with another case law. Otherwise, discovery limited indicates, here we go to another law. These are all laws. Oh my God. The due process clause does not provide discovery other than the right. Okay, here we go again. So she's going over the case laws, and I'm not going to read all those because I just not. Okay, and then it says here, the extent to the motion seeks dismissal. The conduct of law enforcement agents so outrageous that the due process principles would absolutely bar the government from invoking traditional process and obtain a conviction. The conduct the court held would be shocking to the universal sense of justice. Appeals adopted the standard and held that were only concluded violates fundamental fairness and is shocking in the universal sense of justice. It would be outrageous government conduct. And then it goes into the law. Instances in which the trial courts have found outrageous government conduct, and then it goes to all these other cases. Argument. Defense is, okay, the defense in this motion and others in the argument refer to discovery provided the highly exploratory and that there are massive amounts of exploratory evidence, yet provides no specific as to what exploratory, let alone high exploratory. These unsubtained statements should be considered as simple embellishments and dismissed out of hand. Certainly, in the defense counsel calls an accusation of perjury for a witness on the stand, as in heat of the moment, this unsubstantiated statement should be considered the same. The only discovery that should be considered with the motions are states by Cahill as a part of the internal affairs investigation. The defense has provided Exhibit A, which outlines statements by Cahill and potential questions the defense could have asked. This should be disregarded, as mentioned in the clause, confrontation clause, and we'll go to the laws. Okay. A defendant has no constitutional rights to unrestricted confrontation of a witness to introduce evidence at a prelim. Essentially, just because the defense could have questions based upon discovery provided by the hearing, that does not mean the Constitution is violated because they were not able to seek these questions. Looking through a list of questions of what defense would have asked, it's clear that they're not material or would have no effect on the outcome of the prelim. Such questions as to timing, when and who, and what opinion does not go to probable cause, but rather than discovery fishing expedition. The defense persists on claiming as to part of the grand discovery conspiracy that Cahill reassigned with the CBI after prelim hearing that was a result of D.A. Stanley after Cahill testimony at the prelim. The defense opines that this would have affected the outcome of the prelim. This is preposterous, and all these events happened at the prelim, and so even if it was true, would not have affected the outcome. The people are responsible asking the court, or respectfully asking the court, to not allow the defense to question witnesses on this matter. It is a fishing expedition that goes to nothing that feeds to the preposterous notion that we are engaged in some discovery conspiracy. Defense listen to this. Defense contends that they have not seen a single email, document, text, or report regarding Cahill communicated the information that disagreed with the timing of the arrest. The defense contends Cahill's opinion. Cahill's communicated his concern verbally so that no documentation of his opinion further. When and how the person is arrested are issues that are produced in nature. They do not implicate whether there is probable cause, but merely how to comply with the court's findings of probable cause and arrest to order. Therefore, any disagreement between law enforcement and to the prudential issue is not exculpatory, and certainly is not exculpatory if officers disagree whether they should arrest a person at their home versus at work. Otherwise, disagreement as such execute the court order to not exculpatory. Oh my God, listen, this court stuff, tongue twisters. Cahill pinning the time of the arrest is not material. The standards outlined in vaguely. Oh, here we go with the case law. Let's see. It is clear that one law enforcement officer opinion their opinion timing of the arrest would have not affected the outcome of the prelim. As mentioned above, opinions of the timing of the arrest are merely prejudicial and conflicts between law enforcement agencies, although not common, that don't happen regularly. Nothing would have changed if the prelim should be the traditional disagreement between law enforcement have been brought to light. Although there is nothing to suggest, as the defense speculates, Cahill thought there was no probable cause, and he didn't think that the defendant murdered his wife, assuming Cahill has opinion that he thought there was no probable cause at the time of the arrest. It still would have not been material. In the prelim hearing, the standard is probable cause, and the evidence must be viewed in the light most favorable to the people, without conflicts to the evidence resulting in the people versus, here we go with all that. This is a standard following by Judge Murphy at the prelim. He mentioned the unknown DNA found on the victim's SUV using prelim hearing standards, discounting in the favor of evidence viewed in the light most favorable to the people. One law enforcement officer opinion that there was no probable cause to arrest will not change this. Since Murphy had found probable cause at the time of the arrest by signing the arrest warrant, but as mentioned earlier, there was no evidence that opinioned Cahill. Defense also contends that the arrest warrant affidavit contains falsehoods and mispresents, but does not provide any specific again. They rely on blanket accusations with no basis in fact, leaving out disagreements about timing of the arrest and not falsehoods or misrepresents. Wow. The defense attorneys also have proposed the sanction of dismissal and repeats their content with Cahill's statements had been known, then probable cause would not have been found by Judge Murphy. As outlined above, this is preposterous. Oh my God, these words these people use. An opinion of timing of the arrest would not invalidate 4 days of testimony, especially with the prelim hearing standard. The defense contends that people withheld massive amounts of evidence prior to the prelim. A couple of statements by one certainly does not constitute massive amounts of discovery. Of course, after these, the same defense attorneys have alleged a grand conspiracy between multiple state and federal people. It is also stating that the defense is not asking to rehear the prelim as sanctions, as if the defense contend the hearing violated due process rights, and with the last information, it was certain that probable cause would have not been found. Then the natural remedy is to rehear the prelim. The reason to clear why they do not want to redo the prelim, because any judge will still find probable cause even if Cahill's statement. In fact, the judge would more easily find probable cause since we now show there are 3 CODIS hits presented at prelim that are not connected to the case. It is clear that there has been no discovery violation on the part of the people as it relates to the statement made by Cahill, and the defense motion should be denied. Wherefore, the people respectfully ask the court to deny the defendant's motion for sanctions. Signed, Linda Stanley, respectfully submitted on the 23rd day of March 2020. Okay, it's not the 23rd, but hey. There you have it. That is the response. A lot of tongue twisters for me, but thanks for watching.